close this poll so that we can see the results.
Great. Sounds good. Thank you very much, Carla and Marla, and I really appreciate your help today in making this happen. Thank you everyone who made it to this webinar today. Did you want to say anything about the poll, Marla?
No, as I just if you would like to, would you like to see the results?
That would be great. Yeah, let's take a look.
Okay. So we just have who is here and then the answers to the questions that you had provided, the quiz questions, which I assume we will be answering in a little bit.
Okay, so.
All right, and then I can clear out of that and your screen will be on on. Are you seeing your slides now?
I'm seeing the poll. I'm going to take the poll down if I can. There we go. Okay, wonderful.
Right.
All right, here we go. Okay, so for today, we're going to take a look at how and why addiction is a disability under the ADA, how the ADA, the Americans with Disabilities Act, applies to alcohol use disorder and substance use disorders differently. And we're taking a look at ADA protections in employment and in state and local government services, programs, and activities, and in businesses and nonprofit goods and services. But first, I work at a very exciting place, the Institute for Human-Centered Design. We're located in Boston, and the Institute is an international design nonprofit dedicated to the role of design in social equity across the spectrum of ability, age, culture, gender, and economic status. Now, the Institute for Human-Centered Design has been home to the New England ADA Center since 1996. And the ADA Center is one of 10 ADA centers all across the US. And we're funded by the National Institute on Disability, Independent Living, and Rehabilitation Research. We all do the same work. We provide information, guidance, and training, and do research on the ADA. And we're not enforcers. We don't do compliance. We're educators. And if you call that 800-949-4232 number, you'll get an ADA answer to your question, and it will be anonymous and confidential. Now, in your neck of the neighborhood, in the Mid-Atlantic area, the ADA Center is number 3 here, and that's the Mid-Atlantic ADA Center. I would highly recommend contacting them. Their director is Ann Deschamps, and she works very closely with the U.S. Attorney in that area, Steve Gordon. Okay, now on to the ADA. So the ADA is sweeping civil rights legislation signed into law by President George H.W. Bush in 1990. And the ADA prevents discrimination against individuals with disabilities in all aspects of public life, including work, education, transportation, recreation, and all public and private places where the public goes to access goods and services. The ADA is clear. Addiction is a disability. The ADA is a civil rights law that ensures that people with disabilities have the same rights and opportunity as everyone else. This includes people with addiction to alcohol and those in recovery from addiction to opioids and other drugs. So there are hundreds of definitions of disability, depending on who you're talking with. Social Security, or vocational rehabilitation, And the ADA has its own definition of disability. And it is this: to be considered a person with a disability under the ADA, a person must have a physical or mental impairment that substantially limits one or more major life activity. Now, that impairment could be bipolar disorder, diabetes, alcohol use disorder, or a person has a history of a physical or mental impairment that substantially limits a major life activity. And that could be substance use disorder, cancer, heart disease, or a person is regarded as having an impairment. And that means the person is perceived as having an impairment, but does not have an impairment. Now, a person only has to meet one of these three prongs to qualify as a person with a disability. So let's take a quick look at what are major life activities. So if a person has to have a major life, if a person has to have an impairment that substantially limits a major life activity, what are major life activities? These are things that we do every single day. So major life activities include caring for oneself, thinking, learning, working, breathing, sleeping, seeing, hearing, concentrating, walking, lifting, bending, and major bodily functions such as neurological and brain functions. So addiction is an impairment that substantially limits the major life activities of working, learning, sleeping, eating, concentrating, caring for oneself, remembering, and brain and neurological functioning. So addiction is a chronic illness just like heart disease, cancer, or diabetes. Now, addiction applies, the ADA applies to people with alcohol use disorder and substance use disorders differently. So people with alcohol use disorder have ADA protections in recovery and while using alcohol. People with substance use disorders have ADA protections in recovery and when not engaging in the illegal use of drugs. So let's start with alcohol use disorder. So alcohol use disorder is generally a disability, regardless of whether the person is in recovery or currently drinking alcohol. Now, this addiction must substantially limit a major life activity like learning, working, sleeping, or thinking. Let's take a look at a scenario. Michael is often late for work. The third time he's late, his supervisor gives him a written warning stating that one more late arrival will result in termination. So Michael tells his supervisor that he has an addiction to alcohol and that his late arrivals are due to his drinking and needs time off for detox and treatment. Does Michael have protections under the ADA? Yes. Michael is a person with a disability, alcohol use disorder. The employer must grant Michael's request to get treatment unless the employer can prove that his absence would cause great difficulty or expense, what the ADA calls an undue hardship. Now, keep in mind that disciplinary actions prior to disclosure of a disability stand and the warning the supervisor gives Michael stands. The employer can require an employee with addiction to alcohol to meet the same standards and performance and behaviors as other employees. So to summarize, alcohol addiction generally is a disability, regardless of whether it's in the past or in the present. Now let's turn to substance use disorders. Now, a person has ADA protections in recovery and when they are no longer engaging in the current illegal use of drugs. So what does recovery mean according to the ADA? According to the ADA, recovery means that a person is in recovery from substance use disorder. That person has ceased engaging in the current illegal use of drugs. The person could be participating in a supervised rehabilitation program, or the person has been successfully rehabilitated. So what does illegal use of drugs mean under the ADA? It means two things. The first, use of illegal drugs such as heroin or cocaine, and use of legal drugs such as opioids, but the person has no prescription or has a fraudulent prescription or is using more than prescribed. Now here comes the tricky one. What does current mean? Does it mean days? Does it mean weeks? Does it mean months? The ADA says that current illegal use of drugs means illegal use occurred recently enough to justify a reasonable belief that a person's drug use is a real and ongoing problem. So current is not limited to the number of weeks or days, but it is determined on a case-by-case basis or an individualized basis. Now, if an individual tests positive on a drug test, he, she, or they will be considered a current drug user. Let's take a look at another scenario. Lenore has been in recovery from heroin use disorder for 3 years. She applies for a job that she is qualified to do. The employer refuses to hire her because he learns about her past history. Is Lenore protected under the ADA? She is. She has a history of an impairment, addiction to heroin. She has refrained from the use of illegal drugs for 3 years, which is a good indication that there is not an ongoing problem. The employer, the potential employer, violated the ADA when he refused to hire Lenore based on her recovery status. Okay, we're going to take a deeper look at employment. And let's take a look at who has obligations under the ADA when it comes to employment. It is employers with 15 or more full or part-time employees must comply with the ADA, and state and local governments. And they are an employer, and they need to have 1 or more employee to comply with the ADA, and that could be full or part-time. All right, we're going to take a look at a few statistics of Americans at work here. So 9% of all employed adults have current alcohol or illicit drug use disorders. That's 13.6 million workers. An almost equal number report that they are in recovery or have recovered from substance use problems, and that's 13.4 million workers. This is a recent research from the Society for Human Resource Management. So one day, I received a call on the 800 number from a person who is the vice president of a national recovery center. And he asked this question about reoccurrence or return to use at work. And does the ADA apply to this situation? So I'm going to read you the exact question that he asked. He said, can a professional in recovery, such as a social worker, a licensed professional counselor, nurse, doctor, addiction treatment specialist, or peer coach, be fired because of recurrence or return to use at work? What does the ADA say about this? Well, the ADA's answer to this question is, if an employee is currently engaging in the illegal use of drugs, then that person has no protections under the employment section of the ADA and can be terminated without an employer violating the ADA. However, the employer is not required to terminate the employee under the ADA. It is the employer's choice. So this applies whether the employee is in recovery or a casual user because they are at work. and because the ADA is a federal law that is tied to the Controlled Substances Act. Now, the ADA does not limit the employer's choice to offer support or recovery. The employer can offer medical leave for the employee to seek treatment or a modified work schedule to get the necessary support the person needs. Or an employer can offer a second chance agreement. It's the employer's choice. Let's take a look at that second chance agreement. A second chance agreement can be considered only for individuals with addiction and when an employee can be fired. An employer may choose, but it's not required by the ADA to offer a second chance agreement. So in this agreement, an employer agrees not to terminate the employee in exchange for an employee's agreement to receive treatment and avoid further workplace problems. A violation of the agreement usually results in termination because the employee failed to meet the conditions for continued employment. So, the opportunity for ADA protections at work is when a person is in recovery, is struggling to stay in recovery and before engaging in the illegal use of drugs. And getting the support needed must be communicated and taken before the employee illegally uses drugs. So the ADA provides reasonable accommodations to support recovery. And what is a reasonable accommodation? It is a change in the way work is performed. And here are a few examples. Providing a modified work schedule to get needed support. Providing medical leave for an employee to seek treatment, or a second chance agreement. So I want to turn to a different topic here, and it's been asked, what happens if a person has a legal prescription for medication and they become addicted? Well, let's look at the scenario. James became addicted to Percocet while taking the doctor-prescribed medication in a prescribed manner and in prescribed amounts. He wants to take a leave of absence from his job to taper off Percocet. Is James protected under the ADA? Yes, he is. James is legally using a doctor-prescribed drug. He's a person with a disability and may have rights to an accommodation. He needs to discuss the possibility of an accommodation with his boss. Okay, we've covered a few different topics, and now we're going to turn to the topic of people receiving doctor-prescribed medication for opioid use disorder. We're going to start with a scenario. This is a scenario about Julie. She works in an office at a daycare center. She's in recovery from opioid use disorder and is taking prescribed methadone to manage her opioid use disorder. Her boss learns about her history and tells her to get off methadone or you'll be fired. Does Julie have protections under the ADA? What are you thinking? Yes? No? Maybe? Yes. Julie has a history of opioid use disorder and is being regarded as a current user due to stigma and misunderstanding about methadone. I think I'm actually seeing some yeses coming up in the chat in the right-hand corner. So that's great. Most of you know methadone is a legally prescribed medication used to treat addiction, just like insulin is used to treat diabetes. And being a medical treatment for addiction is evidence of rehabilitation, not current illegal use of drugs, generally. Julie's boss is incorrectly regarding the use of methadone as an illegal drug. All right, we're going to continue with Julie for a sec. So what if Julie's employer found out that she recently used cocaine while taking medication to treat her addiction? Would she have rights under the ADA? If you could put your responses, yes or no, in the chat, I can actually see them. I see a no, another no, more no's, and the no's are correct. Very good. No, she has lost protections because she is currently engaging in the illegal use of drugs. Very good, everyone. Now, what if Julie's employer found out that she recently used cannabis while taking medication for her addiction? Would she have protections under the ADA? Please put your responses in the chat. Yes, no, maybe. It depends. See many yeses. See no, yes. Oh, depends on local law. I'm sure. Maybe she has a script. Okay, these are fantastic. What a great audience. Very interesting. Okay, so does Julie have protections under the ADA if she's recently using cannabis while taking medication for her addiction? The answer is no. No, Julie would not be protected under the ADA because the ADA is a federal law. And even with a medical card or certificate or medical prescription, cannabis is illegal under federal law, such as the ADA, because it's tied to the Controlled Substances Act. However, and I think a few people brought this up, you need to check they put it as local laws, and you need to check your state and local laws. Absolutely. Because if medical cannabis is legal under state law, employers may need to consider reasonable accommodations for employees with disabilities for off-site use of medical marijuana. However, an employee who uses or is high at work has no protections under either federal or state law. I'll tell you quickly about a case that happened in my state of Massachusetts. A woman by the name of Jennifer Barbuto, and this is back in 2017, applied for a job at a place called Advantage Marketing. And she was offered the job, but before starting the job, the employer said, "We're going to have you take a drug test." She said, "That's fine, but what you will find is marijuana in my drug test." And she said that she's a person with Crohn's disease, and she takes marijuana in the evenings, off-site, not at work, to ease her pain from Crohn's disease. The employer said, "That's fine." So she starts her first day at work, and at the end of the first day, her immediate supervisor says, "Oh, I'm sorry, I have to let you go because we found marijuana in your drug test." So Jennifer explained the whole situation. He said, "No, that's a policy. That's it." So Jennifer took her case to state court in Massachusetts, and she won that job back. She won it as a person with a disability who had a medically prescribed card and prescription for marijuana, and she took her medication off-site and not at work. So you really need to check your state laws around this. So where marijuana is legal and where there is a prescription tying the medication to a disability, an individual analysis would need to be made instead of having this blanket policy. And you might be familiar that recently it was announced that medical cannabis is moving from a Schedule 1 drug to a Schedule 3 drug under the Controlled Substance Act. This this will allow it to be out of that category of heroin and fentanyl and oxycodone and into a different category that can be sold in a pharmacy with a prescription, like Tylenol with codeine. And it'll also allow for research to be done on marijuana. And this is just for medical marijuana. Okay. All right. Now we're going to move on to the next section, which is state and local governments. Okay. So under this Title II of the ADA, people with disabilities must be able to participate in or benefit from all state and local government services, programs, and activities. For example, the courts, corrections, public education, public transportation, recreation, healthcare, social services, and voting. And recovery residences receiving state and local government funds have obligations under the ADA to serve people with disabilities, including those with medications tied to their disabilities, such as legally prescribed medication for opioid use disorders. If there's no state funding, then it's either Title III of the ADA or the Fair Housing Act, or Section 504 may apply to recovery residences. Section 504 of the 1973 Rehab Act is what the ADA was based on, and it really said this: if you receive federal funds, then you must comply and become accessible to people with disabilities, and that is both programmatically and structurally. So let's look at a scenario about Tom. Tom is taking medication to treat his addiction. He appeared in family court and requested that he begin to see his kids on the weekends. The judge responded to his request by saying, "You'll see your kids when you get off Suboxone." Is Tom protected under the ADA? Let's see what you put in the chat there. Yes or no? Yes, yes, yes. Oh, it was a no. Okay. It's mostly, I'd say 99% yeses, and the yeses have it. Yes, he is. He has a history of addiction. Family court is regarding the use of Suboxone as though it is an illegal drug due to stigma and misunderstanding. Suboxone or buprenorphine is a legally prescribed medication for a diagnosed disorder. Tom's use of Suboxone cannot, by itself, justify a refusal to see his kids on the weekends. Okay. Now we're moving on to corrections. So people who enter the correctional system, not all people, many people who enter the correctional system with medications for opioid use disorder are discontinued on their medications. Are people protected under the ADA? The yeses are running in here, and this is an excellent, smart group. Okay. Well, the answer to this is yes. A correctional system has an obligation to provide medications tied to a person's disability when the correctional facility has a medication dispensary. This includes all forms of medication for opioid use disorder, Suboxone or buprenorphine as it's called, methadone, and Vivitrol. Okay, how do we know this? There was an article in the Journal of Federal Law and Practice and it's called Using the Americans with Disabilities Act to Reduce Overdose Deaths. And the article's by David Howard Sinkman and Gregory Dorchek. It was written in January 2022. So in this journal article by Dorchek and Sinkman, they state that ensuring access to all forms of medication for opioid use disorder is a vital tool in the fight against the opioid epidemic. Here's their data. In Rhode Island, there was a 12% decrease in overdose deaths just 1 year after implementing a medication for opioid use disorder screening and treatment program in its state prison. In Maine, preliminary data showed that people were 60% less likely to die of an overdose in their first year out of prison if they received medication for opioid use while incarcerated. And in Baltimore, annual heroin overdose deaths decreased by 37% after Suboxone became available in the city back in 2003. I'd like to talk a little bit about a recent Department of Justice settlement agreement with the judicial system of Pennsylvania. So the head judge of all of the courts in Pennsylvania ordered all people to get off their medication for opioid use disorder or to limit their use of opioid use disorder. The Department of Justice found that the judicial system of Pennsylvania component courts' policies of imposing taper requirements, prohibiting use of specific opioid use disorder medications such as buprenorphine or methadone, restricting treatment to only specific opioid use disorder medications such as Vivitrol, and limitations on the use of medication for opioid use disorder all constituted violations under Title II of the ADA. So this suit just basically ended up closing in January of this year, 2024. So the judicial system of Pennsylvania has to now identify an ADA coordinator responsible for monitoring court programs and overseeing investigations of ADA compliance. They have to update their compliant process as needed to ensure prompt handling of ADA-related complaints. The courts also have to train and educate all court staff about opioid use disorder and the ADA's non-discrimination requirements, and pay compensatory damages to individuals harmed by this judicial system in Pennsylvania. And recently, as well, was the Parole Board of Massachusetts had a settlement agreement with the U.S. Attorney's Office in Massachusetts. And basically, a complaint was filed with the U.S. Attorney's Office of Boston, alleging that parole officers were forcing participants, parolees, to stop taking their prescribed medication for opioid use disorder without individualized assessment by a medical professional. So instead, the officers ordered participants to exclusively take Vivitrol, regardless of their specific healthcare providers' recommendations. So this settlement basically prohibited the parole officers from specifying the type of drug that the parolees had to take and stop making decisions about their medications and to allow the use of other medications like Suboxone and methadone. This was one of 18 settlement agreements in the state of Massachusetts regarding medication for opioid use disorder. Okay. Now we're moving on to businesses and nonprofits. This is Title III of the ADA, and it requires that places of businesses and nonprofits to provide goods and services to people with disabilities, like social services or healthcare, hospitals, private schools, daycare centers, hotels, movie theaters, pharmacies, and I'm adding recovery residences that are nonprofits or private businesses. They have obligations as well to serve people with disabilities, including those with medications tied to their disabilities, such as legally prescribed medication for opioid use disorder. So again, if you're not a business or a nonprofit, in Title II of the ADA or the Fair Housing Act or Section 504 may apply to recovery residences. Let's take a look at a scenario. Okay, disability rights for people with medication or opioid use disorder and recovery residences. Do residents have protections under the ADA? They do. A person with OUD is a person with a disability and has rights to take their doctor-prescribed medication to treat their OUD. To refuse a person with a disability entry into a home based on their medical prescription may be a violation of the ADA, the Fair Housing Act, or Section 504. All right, now we're going to look at a scenario. Livia is a person with opioid use disorder and is taking doctor-prescribed medication for her opioid use disorder. She's applied to live in a recovery residence for people in early recovery. She's denied admission because the residence has a policy of refusing to admit people with OUD who are taking Suboxone to treat their OUD. The residence manager asks Livia to change her medication or maybe go to another house that allows medication for opioid use disorder because there is no staff to dispense the medication here. Does Livia have protections under the ADA? I see the yeses coming in the chat. There are 100% yeses so far, and the yeses have it. Yes, Livia is a person with a disability because she has a history of opioid use disorder. Excluding her because of her doctor prescription is illegal discrimination, assuming that Livia meets the residence's other eligibility requirements. Turning someone away, asking a person to change their medication or to go to a house that allows medication for opioid use disorder are all problematic under the ADA, the Fair Housing Act, and Section 504. So whether the person has a history of opioid use disorder, cancer, diabetes, high blood pressure, ADHD, depression, anxiety, and traumatic brain injury, it may be illegal to turn that person away based on their prescription medication. A few more signs of discrimination. Limiting the number of people in the facility who can take medication for opioid use disorder, having designated MAT beds. Requiring people to taper their dosage of methadone or Suboxone, or only admit people who take under a certain dosage of methadone or Suboxone. We have one more scenario. Dominic has legally prescribed medication to treat his opioid use disorder. He applies to a certified recovery residence near his home. The residence operator responds that his application is rejected due to their medication policy to not accept certain FDA-approved medications that may be mind or mood altering, including doctor-prescribed Suboxone. Does Dominic have ADA protections? I see yeses coming into the chat. It looks like it's almost 100% yes. Okay, thank you. And you're correct. Yes, Dominic has protections. A policy to not accept certain FDA-approved medications tied to a disability is a violation of federal disability laws. Dominic has a right to file a complaint with the Department of Justice or HUD, Housing and Urban Development, if the resident rejects his application based solely on his doctor-prescribed medication. So the residents needs to change their discriminatory policy to a non-discriminatory policy to be compliant with the law. So a non-discriminatory policy is needed. And a non-discriminatory policy is prerequisite for compliance with the ADA and for making reasonable accommodations and modifications. So reasonable modifications to a non-discrimination policy for people with medication for opioid use disorder are the resident with take-home methadone or Suboxone doses may take their doses to the residence, or the residence stores their medication on site the way others store their controlled substances, or a resident can go to their opioid treatment program for methadone or their qualified practitioner for the Suboxone. All right. There aren't many cases that I can point to regarding housing and medication for opioid use disorder, but one comes pretty close, and it's out of Boulder, Colorado. And a place called Ready to Work is a nonprofit, and it's a program that provides residential work and social services for unhoused people in Colorado. And they discriminated against an individual with opioid use disorder by denying her admission to its program because she used prescribed medication for opioid use disorder. And the settlement agreement between the Department of Justice and Ready to Work is that the staff has to get trained on medication for opioid use disorder and the ADA's requirements. The staff have to report on compliance with this settlement agreement, and the nonprofit has to pay the complainant $7,500 in compensatory damages. There are several other cases. Most have been out of the state of Massachusetts. It's a very rigorous office. And these are about, number one, the Massachusetts Attorney's Office of Civil Rights sent letters to all nursing homes in Massachusetts warning them not to refuse applicants with opioid use disorder. I was at a presentation once, and one of the nurses present said that she has a very difficult time. She works in a general major hospital in Boston, has a very difficult time finding even a rehabilitation facility for someone who's just had a hip replacement or a knee replacement that is also taking Suboxone or methadone. That nursing homes and physical rehabs will not accept someone with this medication. So our U.S. Attorney's Office has pretty much gone after both nursing homes and physical rehab facilities in Connecticut, Rhode Island, and Massachusetts have been hit with settlement agreements because they've refused to accept patients. And this is a pretty common practice of turning patients away with opioid use disorders. It often happens in HMOs and in hospitals. In Selma Medical Associates in Virginia, near you guys, the Selma Medical refused to accept a new patient into a family practice after learning he had a prescription for Suboxone. And now they have obligations to modify their existing policy that excludes people with opioid use disorder. Okay, I have one final slide here, and that is this. So all I've been talking about now about substance use disorder is that the ADA's general rule is that a person engaging in the illegal use of drugs has no rights under the ADA. Well, there is an exception to this rule. When a person seeks health care in an ER or a medical facility and is intoxicated, they cannot be turned away. It is a violation of the ADA for emergency rooms and healthcare facilities to refuse service to people who are engaging in the illegal use of drugs. Right. To our summary. So, people with addiction are people with disabilities under the ADA. The ADA applies to addiction to alcohol and addiction to opioid use and other drugs differently. The ADA protects people with disabilities from discrimination in employment and state and local government services, programs, and activities like the justice system, healthcare, skilled nursing facilities, and recovery residences. The ADA protects people in recovery from opioid use disorder who are taking legally prescribed medication to treat their opioid use disorder. And the ADA can provide guidance on how to care for one another and address stigma in the addiction crisis. So I have left you with many resources, questions about the Americans with Disabilities Act, our 800 number. We have a great ADA addiction recovery fact sheet series, frequently asked questions, and some articles, as well as more resources that you can take a look at your convenience. How to file a complaint. If it's an employment or work complaint, you file with the U.S. Equal Employment Opportunity Commission and their website on how to file, and their phone number and email is available. And if it's a state and local government complaint or business or nonprofit complaint, you file with either the U.S. Attorney's Office of Civil Rights or the Department of Justice. And their information is there as well. So I will take some of your ADA questions. And I would like you to reach out to your nearest ADA center at 800-949-4232 if you think of any after this presentation. And also my direct contact, my email, oharrison@ihcdesign.org. You can directly contact me, or my number is the 800 number with an extension 227. Will get you to my voicemail and to me, if I can answer the phone at that moment. So I thank you, and I look forward to your questions. I'll bring back
Great.
Mara.
Thanks so much, Oce. That was great. Well, first, so some folks are asking about slides. Yes, slides will come to, I will be sending the slides to all attendees, as well as posting this recording on our website with the slides. There are some questions coming in. So Megan asked, what if you have an individual coming to your agency on medical marijuana and you need to comply with drug-free workplace due to funding? Is it okay to require that they not bring their medical marijuana or paraphernalia on site?
Well, so they're coming to your agency for services. That's what I'm going to assume that. Well, so you have policies at your workplace of behaviors and conduct that you do or do not allow. And I would go by those policies. Again, what the ADA says is regarding work and being at work. And well, actually, let me just back up. The ADA generally says that it is illegal. You have no protections under the ADA if you are using marijuana at work. So in this situation that you're talking about, I would really go with your policies that you do not allow marijuana or paraphernalia into your agency. I mean, every workplace has workplace policies that address drugs and alcohol, and basically based on keeping a workplace drug and alcohol free. So I would kind of go with that.
Okay. Another Julie asked if an individual does not admit that they have an alcohol addiction, but they come to work impaired and are tested, do they have protections under the ADA?
So that's when an individual assessment would be preferable. And not only that, but workplaces have specific standards for conduct and performance. And if you begin to see evidence, hear evidence, you have credible evidence that a person is slurring their words, or their head's on their desk, or they've lost a ton of weight, or, very credible evidence that their performance is low, as a supervisor or a manager, whatever, you have the right to address their performance and their conduct, and go on that and try to find out what's behind it. And that is an allowable thing under the ADA, to have that interactions, find out, hey, I see that, your numbers are down, or all of those things that you can see here and measure. You have a right to basically address those things under, the performance evaluation.
Emily asked, what are some recommendations to address local or even state government that declines to see OUD as a disability and states MOUD is not health-sustaining medication, as it is a choice that individuals make to use substances, and she lives in Pennsylvania.
Could you repeat the first part of that, the whole sentence?
Sure.
Thank you.
What are some recommendations to address local or even state government that declines to see opioid use disorder as a disability and states medication for opioid use disorder is not health-sustaining medication, as it is a choice that an individual made to use substances?
So these are legal substances, and the ADA is clear that people with addiction are people with disabilities. So education, 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 outreach, outreach, outreach. This is what I do to get the word out, because it is not surprising anymore how many people do not know about their civil rights under the ADA, who are people with addiction and in recovery. There are thousands. And so finding a way to get that organization or that department or whatever some education around this would be preferable. And if there's any way I can help with that, I'd like to. We can even talk offline.
Okay, and then we had one other one that came in during the presentation. Someone said, I have a client who is in remission for alcohol use disorder and keeps getting denied coverage for life insurance. Is he covered under the ADA?
I don't know about life insurance, and I can't speak to what their policies are. They are an animal unto themselves. And I don't know about any crossover or intersection of the ADA and life insurance. So I'm sorry, I'm not the right person to answer that question.
All right. Well, those were all the questions we had come in. I just want to thank you again, Oshi, for such a wonderful presentation. This was very interesting. I know I learned a lot. For everyone who is still on, I am just going to go over a few housekeeping items. So just thank you again, Oshi, for such a great webinar. We would like to remind all participants that a PDF of today's PowerPoint, along with the recording of today's presentation, will be uploaded to the webinar library located on IREDA's website sometime within the next week. I now want to remind you of our evaluation and CEU process. You will receive a follow-up email from us. It will include a link to the evaluation and step-by-step instructions on how to obtain CEUs. Please note that it will take up to 48 hours for your CEUs to become available because we have to cross-check your attendance records with WebEx. We would like to especially request that you fill out our evaluation. It should take no more than 2 minutes of your time. Again, we want to thank everyone for taking time out of your day to participate today. If you have any questions at all, please email us. The email address is info@ireda.org. And with that, I will conclude today's webinar. Thank you so much, everyone.
Thank you, Marla.
Yes, you're
Have a
welcome.
great day.
Bye.
Bye-bye.